will be supporting this bill. In 2008, the Honourable Annette King introduced the Domestic Violence Reform Bill. It is now at the bottom of the order paper. It, of course, has been abandoned by this government so they could do two things. First, introduce and pass the Domestic Violence Enhancing Safety Bill, which picked up the police protection order provisions of Annette King's bill. And then this left a number of provisions that needed to be passed, hence the bill that we have before us today. But there have been some major omissions from this bill. So when we add up the two bills, the one that's already been passed with the police protection orders in, and this bill, there are still some glaring gaps, and I want to. Oh, so the minister's actually saying that he will address the other issues with the bill? Oh, I don't know about that, but anyway, I will wait to see it. The minister said that he's leaving the Annette King's bill on the order paper so that it can be addressed at a later stage. I will be very interested to talk to him about what that timetable might look like. I'm going to talk about the omissions from this bill because I think it would be very good to know from maybe the next government speaker as to why there is the delay in the additional ones, if it is indeed a delay and not putting off onto the Never Never. I welcome the changes that are included in this bill that came originally from the Domestic Violence Reform Bill, and the minister's gone through those provisions. There's really only one provision in the legislation that was not included in the bill that Annette King introduced, and that was that last one that the minister mentioned. So I'll just quickly run through the provisions of the bill just to indicate the support that the opposition has for these provisions. First of all, the clarifying of the law around the application of protection orders for young people when the applicant dies. That's clearly something that needs to be tidied up. There are, of course, provisions to enable the family court to make interim orders relating to a child's care or vary existing orders even though no application has been filed. And this is important, and it actually came up during the consideration of the discussion document that we had out during the domestic violence review that the previous government was responsible for. And what we identified was that quite often the courts weren't sort of attuned to the provisions of the Care of Children Act when they were looking at a domestic violence application, and so it was therefore important to write this provision in, and I think it's really just to draw the judge's attention to the fact that this is something they should resolve at the time that they're dealing with a domestic violence application. Issues of contact are to be addressed by ensuring that the family court review those arrangements within a few weeks after a temporary protection order is made. And again, this came through very clearly in the discussion document that we put out. It was really important that the law codified the practice that has now been developed in the family court in that regard. It removes administrative barriers to engagement in stopping violence programs, and we know that there are issues around effectiveness levels in stopping violence programs, but where they are willingly participated in, we know that the success rate is much higher, and so therefore removing those administrative barriers is obviously going to be of advantage. The extension of the Care of Children Act to address all abuse, including psychological abuse in terms of the care and contact arrangements. I just want to put on the record that I was on the select committee that considered the bill, and we, after hearing a lot of evidence on this, decided to exclude the psychological abuse provisions that related to the domestic violence legislation from these care and contact provisions in the Care of Children Bill. I think we got it wrong, and I'm not ashamed to say that. Sometimes you do, and sometimes it's a question of a judgment call, and it's based on the evidence that you receive and the submissions that you receive at the time. I think that this is a good tidy up of the legislation. There have been too many gaps left in the difference that exists between the two pieces of legislation. So I really do think that this does strengthen protection for children, as the Minister has said, and I strongly support those changes coming in. And then there is the provision that I've been waiting for a long time. Actually, I don't think the Minister mentioned this particular provision in his commentary, and that was the question of the ability to discharge a Section 105 order, which is essentially a Hague Convention provision ordering a child to be ordered back to the other signatory party's jurisdiction, where in fact the guardianship arrangements should have been dealt with in the first place. The case referred to in the explanatory note to the bill, Butler and Craig, actually involved a constituent of mine, and that's why I've always felt that this was an important case to address. It highlighted a gap in our law, one that is commonly addressed in other jurisdictions. So I don't think people should be nervous about giving the court the power to cancel one of these orders. Other Hague Convention countries do exactly the same, and I think it's important that our law allows for that as well. Finally, the bill makes changes to the Adoption Act, which introduces the 7-year sentence for inducing another person to consent to an adoption. I think the point that the Minister didn't make is that the whole point about bringing in the 7-year sentence is to create an extraditable offence, which gives us the international reach that unfortunately we didn't have with our existing law, and it does enable the ratification of the optional protocol to UNCROC, as the Minister said. I do totally support this change. It is a serious matter internationally, and I just reflected on the scene in Haiti with the group of people going in and just grabbing children to take out for adoption. Now, I don't know what their motives are, and I'm not making a judgment call on them. I'm just saying that in those sort of situations, you have to be really, really careful that the law is strong enough to protect against the unlawful trafficking in children, because it could have been that. Who knows whether they were a genuine outfit or not. So it is very important. I remember attending the World Conference on Women back in 1995 and being at a table with a group of women politicians from Romania, and the impact of the international adoptions on their children, and knowing full well that they were taking personal responsibility for wanting those children to be cared for, the terrible scenes that we saw from the orphanages back then. But sort of basically the message that they were giving other politicians from other countries was, stop stealing our children. We have a problem. We need to address it. But think of the long-term impact on children totally ripped out of not only sometimes family engagement, because family members, as we saw in Haiti, will sell their children not for personal benefit, but knowing that their children will have more advantage educationally, possessions, whatever, they will allow their children to go. But the long-term emotional damage that can be done in that situation, dragged away from family, culture, language, all of those things, and there has to be the capacity to return as well. So that's it's a good change that the Minister's bringing in, and certainly has support on this side of the House. UNCROC compliance is obviously important, but it's kind of made it ironic by the exclusion from the other bill, which is the definition of a minor. And I think it was really important that we lifted the age from 17 to 18. Again, not just for UNCROC compliance, but it made me wonder whether there was a connection between the bill that we're just dealing with, that drops the age of criminal responsibility for a range of offences in addition to manslaughter and murder in terms of the youth court jurisdiction, and whether that's got something to do with the failure of the government really to allow addressing the problem where 17-year-olds just simply can fall through the cracks. And if you think of, and I was thinking of what the Minister was saying about, the circumstances that these young people can find themselves in, exposed to family violence. And then I'm hearing the conversation or the debate that we've just had on the previous bill, and you think about the long-term consequences of the damage that domestic violence does on children, even when they're just hearing the violence or experiencing the violence around them rather than directly, that long-term damage can lead to the sort of outcomes that we were just talking about with the previous bill. So I would like to think that we could address that at some stage in the very near future. There are a couple of other provisions that have been left out. The question about without notice applications for protection orders being declined, the need for written reasons. These were based on very, very important reports that were done for both the Ministry of Women's Affairs and for the ministerial group and the task force on family violence, and I think it's really important that the government thinks seriously about including these additional provisions in the bill sometime soon.